Hello everyone and welcome to the third of our video tutorials on the topic of lay people. In our first video we looked at lay magistrates, in our second video we looked at juries, and in the video tutorial today we're going to look at evaluating both magistrates and also juries. And on exam 1, section B, you could get a 15-mark question asking you to evaluate the use of magistrates in the English legal system, or the use of juries in the English legal system, or potentially, harder questions still, asking you to evaluate lay people, in which case you would have to talk about evaluation of both magistrates and juries. So we're going to have a look at that today. So if we start then by looking at some key advantages of the use of magistrates in the English legal system. First of all, big advantage is that they promote active citizenship, which means that ordinary people are being involved in the English legal system, and that leads to an open system of justice. And that might also link to why perhaps there's public confidence generally in the use of lay magistrates. Another big advantage you can see here is that they are more representative than our professional judges in terms of gender. So in 2019, 56% of our magistrates were women, which is favourable compared to our professional judges. Some people say that magistrates are better placed than judges in some instances to be making decisions. And one factor in that might be that the fact that they sit as a panel of 3 means that you've got 3 opinions and 3 views on a case rather than just one, and that might be a real benefit in perhaps avoiding individual prejudices. Another advantage is that lay magistrates work in a magistrates court in their local area, and that means that they have local knowledge. So they'll be aware of particular issues in their town, particular crimes or things that are being particularly problematic in that area. And they can bring that local knowledge to their case. And we've got a case here, it's an old one, Paul and the DPP, but it does show quite nicely in this case a lay magistrate was very conscious of the impact that curb crawling was having in the local area. And they were able to utilise that knowledge to pick an appropriate sentence for that particular area. Another key advantage is that when you think that magistrates are working in the magistrates court, which is our busiest criminal court, which hears approximately 1 million cases a year, and between 95 and 98% of all of our criminal cases, if we didn't have lay magistrates, we'd need a lot more judges. And the statistic I found said that we would need an extra 1,000 judges to replace the lay magistrates. And that links to the next point, that because lay magistrates are unpaid volunteers, they are therefore cheaper than using the professional judges. And the estimate that I found says that we save £100 million a year from using lay magistrates compared to professional judges. Now, lay magistrates are not legally qualified, and you could say that's a criticism. But in terms of an advantage here, we can say that they have constant access to advice. So they'll always be supported by the Justice's clerk, who is legally qualified, so they will always be able to have access to points of law, any guidance on the law that they need from the clerk. There's also few appeals made against magistrates' decisions, which might suggest that they are doing their job effectively and that people are happy with the decisions that are being made, which again links back to the fact that there does seem to be public confidence, this idea of being tried by your peers, I suppose. So the public tend to have faith on the whole in the use of lay magistrates. In terms of disadvantages then, we saw on the previous slide that magistrates are quite well representative in terms of gender, because 56% of them are women, but generally they are underrepresentative of society as a whole. Most of them are drawn from the middle classes, from managerial occupations, and that has led to the accusation in newspapers that magistrates are middle-aged, middle class, and middle-minded. This idea that they're unrepresentative, they are from a very narrow socio-economic background, which might affect their judgment in cases. This accusation seems to be supported by statistics. In 2019, we found that only 5% of our magistrates were under the age of 40, the average age being 57. And the age of magistrates is a particular concern when you bear in mind that magistrates are also trying most of the offences committed by young offenders aged 10 to 17 in the youth court. So if they're all much older, there's a concern that perhaps they're not able to empathise as easily with the defendants. Maybe they're not in the best position to pick sentences in terms of rehabilitation, etc. So the age is a concern. In terms of other disadvantages, we said previously that it's good that magistrates have local knowledge, and it is. But we need to be aware of the fact that lots of local magistrates' courts are closing. So the magistrates' court in Widnes has closed, and that means that magistrates who worked there previously are now travelling to another magistrates' court in Liverpool. Some of them might have problems accessing courts that are further away, and that might lead them to leave their job. They might not want to be a magistrate anymore. And another disadvantage is that we're then losing local knowledge, because if they're travelling to a different court, they're not going to have the same understanding of the particular issues from that area. Magistrates also have a low acquittal rate. So that means that they find defendants guilty a lot of the time, certainly compared to Crown Court cases where you've got a jury. You are 3 times more likely to be acquitted in the Crown Court than you are in the Magistrates' Court. So this low acquittal rate seems to suggest that they're prosecution-minded, which I'll come back to in a second. And we're also seeing, as well as a low acquittal rate, that there is an inconsistency in sentencing. So magistrates in different areas, although they'll all be following the same general guidelines, they will be applying them differently. And that has led some people to say it's a postcode lottery. Just coming back to the low acquittal rate, that links with the accusation that they're prosecution-minded. So there is a concern that magistrates are perhaps too willing to believe the police over individual defendants. And in this older case, Bingham Justices, the magistrates actually admitted that their general rule was that they believe the police. Obviously, that is a huge concern in terms of achieving justice. There's also concern that they might be case hardened because of the sheer volume of cases they're seeing every year, a million cases going to magistrates' courts, that it's sometimes described as conveyor belt justice, that they see so many cases, case after case after case, that they're not necessarily seeing things with fresh eyes, they're becoming quite case hardened. And sometimes they're over-relying on the clerk for legal advice. And you could make the point there that if they're using the court clerk too much, why do we have the magistrates then? Why not just use the court clerk? So we've looked at some advantages and disadvantages of magistrates there. I'd like to move on now and look at juries. There's a huge volume of advantages and disadvantages you can talk about with juries. You can see just by the sheer amount that's written on my slides here. So I think this is a really, really interesting area. I'm not going to go through every single one of these points, and you can certainly add to them from other sources, but I'm just going to go over some of the key advantages and disadvantages with you. So an advantage that overlaps with magistrates is that being on a jury is a really important civic duty, and it encourages active citizenship. So similarly to magistrates, it means that ordinary citizens are playing a role in the administration of justice. And the Magna Carta, remember, formally acknowledged the principle of an individual's right to be tried by their peers. Devlin famously very much in favour of juries, and a quote that would look lovely in your exam questions is that he described juries as the lamp that shows that freedom lives. There's evidence that juries are less prosecution minded, less case hardened than judges, and that will be because, of course, a jury, they're probably going to do it maybe once in their lifetime, so there's not that conveyor belt justice. They are coming to a case with fresh eyes. And you can also say that the 12 opinions are potentially safer than the view of one single judge. So any individual prejudices hopefully will be balanced out by the fact that all 12 people have to come to an agreement. And you can say, we call it jury equity, that the verdict of a jury can be viewed as those of society rather than those of professional lawyers and judges. And the fact that we saw last time that juries are independent, their decisions cannot be challenged, that's really important because it allows perverse verdicts to occur. And a perverse verdict is where a jury makes a decision that seems to go against the evidence, which I know might sound like a disadvantage, but actually it can protect from abuses of the state. So if, for example, the state did create a law that a jury felt was wrong, it can choose to ignore the law, if you like, and do what it thinks is right in that case. And that links to layman's equity. So the defendant can be found not guilty when legally he is, and that protects from harsh or unjust laws. It's a protection from the state. The public have a lot of confidence and faith whenever the government tries to limit trial by jury. There's usually a bit of outrage about that. People have confidence in the system. And there is evidence that they don't discriminate. There have been studies about whether they are making decisions based on prejudice, and it seems to be that they are not discriminating. In terms of disadvantages then, they have high acquittal rates, which is good, I suppose, if you're the defendant, but it does seem to suggest that if their acquittal rates are so much higher than the magistrates' courts, seemingly then they are finding some people not guilty when actually legally they are. Juries, although they're not paid, they do make trials slow and expensive. They cost 3 times as much as magistrates' trials because you still have to pay for expenses. There's a concern that because people are forced to do jury service, maybe they'll just do a bit of a rubbish job, they're not really bothered, they just want to get home, so they might agree with the majority just so they can get back to their normal lives. A study by McCabe and Purvis found that a jury can be dominated by a strong individual. So that makes me think of the film 12 Angry Men, which is really good if you've not seen. Excellent one on the jury. The fact they don't have to give reasons for their decision, the secrecy of the jury room, some say that conflicts with Article 6 of the European Convention on Human Rights, because for all we know, they could be tossing a coin to reach their decision. And there's a concern as well that some of them don't understand what's going on. A report from the Ministry of Justice found that 2/3 of jurors didn't understand the judge's legal directions, which is really worrying because, of course, we want to make sure that they know what they're doing. There's also a concern that the media might heavily influence the decision of a jury, and it might not be possible then to get a fair trial in those cases. It is also possible, of course, that jurors might be intimidated or bribed. And I've referred to some cases here, and I'm just going to show them on the next slide. I'm actually running out of time on my recording here, but I suggest that you pause the video at this point and have a little look at some of these cases which illustrate some of the disadvantages of using juries These cases obviously not particularly desirable in terms of outcome.